On record, good morning, sir, as you appear to be muted as the public defender there.
Uh,
Oh, not yet.
no,
We're still waiting.
Okay, hey, great. We'll continue to wait. Is that? With the, address the 8:15 hearings, is Leah Humphrey, are you Leah Humphrey? Wait. Apparently she is en route and called and said she would be late. We'll await her presence. Also, we have Robert Williams, and that was an SOC. No payments have been made. This goes back a bit.
City's not taking any action on it.
No warrant, no, just let it be strike. No, I would have expected, Mr. Haverco to be at the jail by now. Mr. Higgins, good morning. Are you able to hear me? You're muted. Could you unmute yourself?
Yeah, I can hear you.
You hear me now?
Yeah,
The reason I said a little bail on you is problems with treatment, then problems with you appearing in court. The last thing we heard from treatment was on December 12th of last year, that their last contact with you was last November. You were discharged on 12/12/22 for just not addressing treatment at all. Haven't heard from you since.
was that last contact from Providence or through CMAR?
That's from CMAR.
Okay, because yeah, I had switched through CMAR and I was supposed to get you that paperwork. Did you receive that?
Where now?
What was that?
Are you getting treatment anywhere besides CMAR?
No.
The last we heard from CMAR was December of last year. Now, I don't know if you've done anything with them since.
Yeah, they didn't have a treatment plan for me. They didn't set anything up.
Yes, they did. Yes, they did. They prepared a treatment plan and then
The paperwork that I'd sent in had nothing moving forward for a plan. I can try to get that sent into you if that's not what you have, or go get another assessment, I guess.
we have the evaluation. We also have the discharge statement for not addressing treatment and being positive for amphetamines and methamphetamines.
It shouldn't have been through CMAR. Through Providence, it was, yeah.
Now, look, I don't want to hold you in jail. You can't do much of anything there. My inclination is to start you with a new court date, and this time show up, okay?
Okay, do you want me to get a new assessment?
Well, I want you to check back with CMAR and see what you need to do.
Okay,
That's according to them, they haven't seen you since last year, November.
all right.
They haven't seen you since then. It's time to, hey, sometimes people drop out. Sometimes it takes more than one address to treatment to get started on it. We're going to give you another court date. That'll probably be August 17th at 8:15 in the morning. What I want you to do is between now and then, you'll be released unless you have another hold on you from some other court. Check back with CMAR, find out what you need to do to get back in their good graces, and at least show up with an appointment with them on the 17th.
Absolutely.
I'd like to see you in person. Hey, if there's a situation in life you need to deal with, let's get started dealing with it, okay? I don't want to see you back in any court on new violations. Mr. Higgins, you take care of yourself, and yeah, if you tell some judge you're going to be in court, make sure you be there. Okay?
Absolutely, sir. I'm very sorry about that.
Let's just start from fresh on August 17th, okay?
Will do.
Take care.
Take care.
Well, come on up and we'll address your matter now. Please, yeah, go ahead and have a seat. Our jurisdiction is ending September 18th, a little more than a month from now. Looks like you have a new violation, and the new violation is, it looks like in warrant status. That's, it looks like you have 2 cases in warrant status. I don't know what we can do. You obviously don't have a resolution of either of the cases that are pending, and you're probably not going to get a resolution while they remain in warrant status. I don't have the authority. They aren't issued by me, so they're out of another court. Given that our charge is a simple misdemeanor criminal trespass, our jurisdiction ends September 18th. Is there any point? I don't see any point in bothering you. You've got more problems to deal with than us. I would make sure you quash your warrants and get started on those cases. If you don't, when warrants are out for somebody's arrest, they usually get picked up on at the worst possible time. So I would address that quickly. Good luck to you. You take care of yourself. I'm simply going to close the case and just simply strike the hearing, and the jurisdiction will end of its own momentum on September 18th. Good luck to you. Like Mr. Girl is online, and his client is in the courtroom.
Yes, Your Honor.
If you want to come up and have a seat. Good morning, Mr. Girl.
Good morning, Your Honor. Good morning, counsel.
Your client is here in the courtroom. The matter is set for a pretrial today. I'll turn to the lawyers to address the status of the matter.
Your Honor, after speaking with Mr. Girl, city's moving to dismiss this matter without prejudice.
I don't think I'm going to hear any objection to a order of dismissal without prejudice.
You won't, Your Honor. Thank you. I appreciate that from the city.
Mr. Molina, the charge is dismissed without prejudice. What that means is if the city changes his mind, finds further evidence, or for whatever reason, has the option of refiling it. It's my experience, and I'm sure your attorneys as well, that once a case is dismissed without prejudice, it's extremely rare matter for the matter to come up again. Mr. Earl, that concludes the hearing. Case dismissed.
All right. Thank you. Good day. Thank you, counsel.
Thank you.
Now, Brent did have a kind of a simple form that he used. So is there something in?
Yeah.
Oh, yeah, I just put it in.
Without prejudice, sign at this time. And copy goes to Mr. Burrow. Ms. Molina, that concludes the matter. You're free to leave. I would just, if you change your contact information, I'd let your attorney know, just in case. Just in case. You take care. Have a good day. Been a good day so far. Take care. You want to go ahead with Mr. Gargile? It's, 3 and 4. Reason W. Young. They're not responding. Oh. Good morning, Mr. Gargile. That's you were muted, but I think you are now. Are you able to hear me?
I can hear you loud and clear. Good morning. How are you?
Hey, not bad at all. The sun is starting to come out here. Looking forward to a good day. I looking at in O courts at an agreed an motion to continue the matter to September 28th, 2023. Is that correct?
That is correct, Your Honor. And for the record, Tony Garchwell, on behalf of my client who is appearing through counsel pursuant to 3.4, I think we likely have a resolution on this. I probably didn't need that long continuance. Unfortunately, the days that are available are just conflicting with my calendar. So that's the first available date for me. Client did give me authority to execute a waiver of speedy today. Talked to him before court, logging on today, gave me that authority. So I believe we should have a resolution at the next hearing, but just need a little more time to look at a few things.
September 28th it is, and you're in touch with your client. I guess
Yes.
that concludes the hearing. We'll send you and your client Mr. Young a copy of today's order.
Thank you very much, Your Honor. Good to see you. Thank you, counsel. Hope you guys have a wonderful rest of the day.
Likewise, and you as well. Take care.
Take care.
Back on record, call the matter of Yelm versus Tyler Anderson. Ms. Backus, I understand you're present, but muted. Well, if you'd unmute yourself, we'll address your matter at this time.
Yes,
And-
good morning. John, are you? I imagine you're referring to me. I didn't hear everything that you said, though.
Okay, yeah, so we're gonna call your matter now. I understand you had a little difficulty logging in, but here you are now. We'll address your matter.
Thank you, Your Honor. Thank you very much. I apologize for not having the video capability. As you know, I'm Gloria Backus, and I represent Mr. Tyler Anderson. Mr. Tyler Anderson has had some medical concerns, pretty serious, but I'm happy to report to the court today that he is doing quite well. Unfortunately, I have not had a lot of time to work this matter. I have transitioned from the firm that I was working with to a solo practice, and Mr. Anderson continues to be my client, of course. I need to file an updated notice of appearance with change of address, which I plan to do this week. And in the meantime, also I had reported to the court previously that because Mr. Anderson has matters pending in this jurisdiction, the city of SeaTac and Pierce County, I intend to work on a resolution that encompasses all of the outstanding criminal allegations against him. And I just have not had the time to do the appropriate coordination between jurisdictions yet, but I will. And I anticipate that, I hope before the summer is over, I will have something to report to the court.
Hey, why don't we just note the non-appearance for speedy trial purposes only and reset the matter to August 17th, August 31st. Do you have Ms. Backus, do you have a preference?
I'm looking. At night, will it be at 9 a.m., Your Honor?
Pardon?
Does it have to be at 9 a.m.?
Does it have to be at 9 a.m.? Doesn't have to be, I suppose.
I can do the 31st, but I do have a 9 a.m. thing in the dependency court, which I'm pretty sure I can move.
You want to go to September 14th with us? That'll give you a little more time.
That would actually be better because I don't have anything that day.
Let's do that then. We'll sign an order resetting the matter to September, and we'll send you and your client a copy of that order, okay?
Thank you very much, Honor. I appreciate it.
Backus, thank you. That concludes the hearing. You take care. Have a good day.
Thank you.
Oh, the pretrial calendar. I understand we have private counsel here. We'll address that matter first.
So the little interesting MEDD, everyone knows.
Absolutely, absolutely. Thank you.
City, I think probably the first thing needs to be done is I need to be substituted in as council, Your Honor.
So ordered.
And then I was asked to set this over, I was asked to set it over a little longer than normal. I'm out of town for most of the August Thursdays. And so,
We can go to September 14th, 28th. Parties have a preference.
28th, I think would be perfect, Your Honor. I'm here and available.
Stratfield, no objection? We'll reset Mr. Reed, we're going to reset your matter to September 28th. Any conditions of release or earlier set remain in effect, and also stay in contact with your attorney and be back here at September 28th.
Does court need to sign the reports or is it just?
We're in all courts. I'm notice of a hearing, September 28th, 9 a.m. You get a copy of that at the counter as you leave the courtroom and
Thank
do
you.
relax. Mr. Mead, concludes the hearing. We'll see you at the end of September. Take care.
Call, are we ready next one? We are, yes, okay. We could call, on the 10 o'clock, Mr. Yeah.
The city is moving to dismiss. I'm not hearing any objection from your attorney. That'll be the order, with or without. With prejudice. On presentation, I'll sign an order to that effect. Mr. Guerra, that concludes the matter. Case is dismissed. Free to leave.
Appreciate it.
You take care of yourself.
I'll tell you, I apologize.
Hey, that's
It's more frustrating.
no problem, no problem. I experience the same frustrations when I have to deal with aspects of the bureaucracy that I won't go on. But hey,
All right.
no need to apologize. You just take care. Have a good day.
Zachary Hurst.
Morning, sir. Zachary Joseph Hurst. Matter comes on for a pretrial this morning. I'll let your attorney address the status of it.
Two matters come before the court, pretrial hearings, and I've had discussed the case. He has some other matters that he wants to track this behind essentially. So we're making a motion to continue. And so when is your next court date, Scott? Okay, so maybe set it over, and what is that, for a pretrial or? Oh, okay. So when's your trial? Oh, okay. So it looks like he's scheduled for trial in his Superior Court matter this month. So perhaps we could set this at least into September.
14th to 28th.
How about the 28th?
Hearing no objection from the city, Mr. Hurst, we're gonna reset the matter to September 28th. Now, in the meantime, stay in touch with your attorney and let him know how things are going. And any conditions released earlier said remain in effect. You take care of yourself. Any questions at all? Signing the order to reset it to that date. I want you to get a copy of today's order at the window outside the courtroom and to your left. Mr. Hurst, in the meantime, take care of yourself. Have a good one.
So on the 11 o'clock, Adriana Hernandez. So the matter comes on, Ms. Hernandez's case comes on for pretrial hearing, malicious mischief, third. And parties have reached an agreement. There's a stipulated order of continuance.
I'm having a little.
Oh, I'm sorry, Joe. Sorry.
Donnie, I'm having
Sorry.
trouble here. Apparently editing this. They signed it once, it unsigned me, and now back to here. Mr. Back with you. Adriana Hernandez, good morning. I'm looking at the stipulated order of continuance in the Oak Court system. I'll defer to your attorney for the to address the matter.
Judge, the matter comes on for pretrial hearing.
Hernandez, this is a contract between yourself and the city, negotiated by your attorney, under the terms of which, if you just stay out of trouble for the next year, pay $250 by way of a monitoring fee. Most importantly, law-abiding behavior. Charge will be dismissed. It will go on your record as dismissed. Now, in return for the agreement, you've given up your rights to go to trial, have a hearing, confront witnesses, appeal if you lose. If there's a violation of the agreement and the city proves that, we're back to square one and we'll have a hearing based on the police report, and that would almost certainly result in a conviction for the offense listed. You have a chance here to get the matter dismissed, but it's up to you to take advantage. Any question at all? I'm going to wish you the best of luck. It's one of the rules of life. If we don't learn from our mistakes, we're condemned to repeat them. We all make mistakes, but not everybody learns. I'm going to wish you the best of luck. What I want you to do is get a copy of the SOC, they call it, at the window outside the courtroom to your left, and look it over carefully. And if you have any questions at all, give Mr. Abercrombie a call, okay? Good luck to you. Take care. Had better luck.
Let's see, next matter would be David Chrisman. See.
Good afternoon, sir. Is your full name David Crispin? Let's see.
Give me 1 second, Judge. Matter comes before the court, pretrial hearing, a protection order violation. Parties have reached an agreement that he's going to plead guilty to the amended charge of disorderly conduct. It's a non-DV, make it very specific. It's a non-DV charge. It's just suspended jail time, $250 court fee, conditions next 12 months, no criminal law violations. Obviously, it'd be a good idea not to violate that order if that order is out there. And then after, 12 months, then the case can be closed.
With a dismissal.
No, it's not going to be dismissed, but it's just going to be closed. Well, they didn't.
Mr. Crispin, do you disagree with anything at all Mr. Haverko just said? Do you disagree at all with anything your attorney just said? I'm looking at a statement of defendant on plea of guilty to 1 count of disorderly conduct, amended down from a protection order violation charge. Plea form tells me you're 54 years of age. Are you 54 years of age? Have you gone over the plea form with your attorney? You understand if I accept the plea, I could sentence you up to 90 days in jail and up to a $1,000 fine. You realize that?
Yes.
You give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. You understand that?
Yes.
As to 1 count of disorderly conduct alleged to have occurred within the city of Yelm on June 27, 2023, how do you plead guilty or not guilty?
In which charge? Disorderly conduct? Guilty.
Disorderly conduct. Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? Is there anything you'd like to tell me before I impose sentence? Anything you think I should know? Sir, I think we're done.
Nothing to add, Your Honor.
I'll follow the recommendation, 90 days, all suspended on the condition you have law-abiding behavior, stay out of trouble, okay? $250 probation monitoring fee, which you can pay over time. Now, the jail time is suspended on the condition of law-abiding behavior, stay out of trouble. And that especially applies to any orders of protection. If you're under an order of protection, you need to abide by that. Violation of that is a serious matter. Crispin, I'm signing a judgment and sentence electronically. I want you to get a copy of this at the window outside the courtroom and to your left. Look it over carefully, and if you have any questions, give Mr. Haverko a call, okay? Good luck. And the acoustics in this room are horrible. So, bad acoustics anyway. Okay.
Yeah, just talk to the clerk before you go. Yeah. Right. Okay. Yeah.
I can now talk. That's yeah, the acoustics in this room are pretty terrible to begin with.
Next matter would be Lance Daub or Daub. It's number 4 on the 10 o'clock.
Morning, sir. Is your full name Lance Allen Daw? Yes. I'll defer to your attorney.
So the matter comes on before the court for a pretrial hearing on a theft charge, and he is going to be entering a plea. I have previously discussed the case with him and reviewed the statement and found him plead guilty, which is in old courts for your review, Judge.
Mr. Daw, I'm looking at a statement of defendant on plea of guilty here on the computer screen. Have you gone over the form with your attorney? Plea form tells me you're 53 years of age. Any difficulty understanding the process? You're pleading guilty to a one count of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Now, regardless of what's recommended, I would be free to impose up to that maximum if I saw fit to do so. You realize that. And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, just simply a sentencing. With that in mind, as to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on June 29th, 2023, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made. I read the recommendation right. It's all jail time, 364 days suspended on the condition you stay out of trouble, have law-abiding behavior, no criminal law violations, and pay a $250 probation monitoring fee. You realize that? Stratfield City, have anything to add? Mr. Haverko, anything to add?
Nothing to add, Your Honor. Just ask the court to follow the recommendation.
Mr. Lott, anything you'd like to tell me? You have a right to what they call elocution. Anything you think I should know or want me to know, now's the time. You don't have to say it. What I'm hoping is this a learning experience, and always try and put yourself in the position of the other side. How would you feel if you went to look at something and it was that you owned and it was gone because somebody had helped themselves to it? Always try and look at it that way. And of course, following the recommendation, all jail time suspended on the condition you have law-abiding behavior and pay a $250 probation fee. Now, the important thing to me is the behavior. If you have trouble making the fine payments, let us know. That is something we can very definitely deal with. Any questions at all?
Just hang on a second. We have to sign the judgment.
I'm tempted to say I'm including the paperwork, but it's more computer work than anything.
For your judgment.
Yeah. Right. So now what I want you to do is get a copy of today's paperwork at the window outside the courtroom to your left and review it carefully. And if you have any questions, give Mr. Haverko a call, okay? Good luck to you.
Next matter would be on the 11 o'clock calendar. And this is Alyssa Kaiser with a K. Comes before
Ms.
the
Kaiser.
court. Comes before the court on a pretrial hearing on assault 4th degree. And parties have reached an agreement. She doesn't have a record. So the parties are proposing a stipulated order of continuance that the matter be continued for 12 months on the condition she have no new criminal law violations, pay a $250 court fee, at the end of which time the city would move to dismiss.
Ms. Kaiser, do you have any disagreement with anything Mr. Aberco just said? Your full name is Alyssa Delinda Kaiser. This is an agreement under the terms of which this charge can be dismissed 12 months down the road if two things: you stay out of trouble. That's by far the most important. Stay out of trouble, law-abiding behavior, and to pay $250 by way of a monitoring fee. If it becomes difficult to make the payments or impossible, let us know. That is something we can definitely deal with. Now, in return for this agreement, you have given up the right to go to trial, have witnesses, appeal if you lose. If we violate the agreement and the city proves that you violated it, we'll have a hearing based on the police report. And that would result in the possibility of jail time, et cetera, et cetera. That's a gross misdemeanor. Now, hopefully this is been something you've learned from, and you'll make good on the SOC, and we'll be able to close the case anyway. Any question at all? I'm going to wish you the best of luck, and you take care of yourself. And again, get a copy of the SOC at the window. Look it over carefully, and Mr. Aberco's there to be called if you have any questions. Good luck. Thank you.
So now I've got about 3 folks to talk to, but I haven't chatted with yet.
We'll be in recess until Mr. Aberco's had a chance to discuss your case. Wow. Back on record,
Thank you, Judge. So this is Carissa Goler. It's number 5 on the 10 o'clock calendar. Comes before the court on a pretrial hearing on a theft charge from 2020. Parties have reached an agreement, that being a stipulated order of continuance, the matter to be continued, set over for 12 months on the condition she have no new criminal law violation and pay a $250 court fee. And at the end of which time the city would move to dismiss.
morning, ma'am. For the record, is your name Carissa Renee Goler?
Yes.
I,
No, you did good.
if there's a way to mispronounce a name, I'm going to do it. But I'm looking at the stipulated order of continuance here in the Oak Court system. That's a contract negotiated by your attorney with the city under the terms of which 12 months down the road, this charge can be dismissed if you do 2 pretty simple things. 1, stay out of trouble, law-abiding behavior. 2, pay a $250 probation fee. That's the least important thing. If you have trouble making the payments, let us know. We can certainly deal with that. Now, in return for this agreement, which will result in a dismissal, you've given up your right to go to trial, have witnesses, appeal if you lose, and there's a violation of the agreement. We'll have a hearing based on that, and the city proves the violation. We're back to square one. That'll result in almost certainly a plea or a finding of guilt and the possibility of jail time. No, we learn from our behavior. We learn from the mistakes we all make. If not, we're condemned to repeat. Hopefully, this has been a not too painful learning experience. I'm going to wish you the best of luck. I sign off on the agreement. What I want you to do is get a copy of it at the window outside the courtroom to your left. And at your leisure, review it carefully. And you may have a question, may not. But if you do, give Mr. Haverhill a call. Any questions of me?
No.
I wish you good luck. And I take care of yourself.
Yeah. Derek Berger. You follow me?
Now on record.
Thank you, Judge. So this is Derek Berger, items 1 and 2 on the 10 o'clock calendar. Parties have reached an agreement. He is going to plead to, street plea to both charges on the earlier case with the XZ. On the court's acceptance of those pleas, the city will move and dismiss the new case. Conditions, all suspended jail time, 90 days in jail suspended on the suspended third. 364 suspended, all suspended on the interlock violation, $250 probation fee. Conditions, no new criminal law violations for 12 months.
Good morning, sir. For the record, is your name Derek Martin Berger? Mr. Berger, do you disagree with anything at all that Mr. Haverko just said? I'm looking at a statement on plea of guilty to 1 count of driving while license suspended, revoked in the 3rd degree, and 1 count of operating a vehicle without ignition interlock. Both offenses alleged to have been committed on June 20th of 2020. In return, there's a dismissal of a second citation ending 6497 for the same thing, both those 2 charges. The plea form tells me that you're 52 years of age. Any issues at all reading, understanding the plea form? And you went over the plea form with your attorney? Now, if I accept the pleas, I can sentence you to up to 90 days in jail and up to a $1,000 fine on driving a license suspended, and up to 364 days in jail and up to a $5,000 fine on the ignition interlock violation. You realize that. You also give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. With that in mind, is to 1 count of driving while license suspended, revoked in the 3rd degree, and 1 count of operating a vehicle without ignition interlock when required to have that by the Department of Licensing. Alleged to have occurred within the city of Yelm on June 20th, 2020. How do you plead guilty or not guilty? You make those pleas of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find your pleas to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. Heard the recommendation. Any recommendation as to a fine or probation costs?
It should be in the form, Judge. $250 probation fee, probation for bench probation for 12 months. Only condition,
Got it.
no criminal law violations, and then the case can be closed.
Mr. Redfield, anything to add? Mr. Berger, is there anything you'd like to tell me? That's it. I'm going to follow the recommendation. 90 days, all suspended on the driving license suspended charge. 364 days, all suspended on the ignition interlock charge. Suspended on the condition you have law-abiding behavior. That would include not driving unless your license is insured and having ignition interlock when it's required. Now that second requirement, that's this is all going to drop off. Your insurance premiums will go down. Your license record will look better in time. But give it that time. Don't keep reoffending, and that just adds to the issue. Anything you'd like to tell me? Anything you think I should know? You don't have to say anything.
Oh, no.
But
Just trying to get my life back together in another meeting.
hey, don't give up on it. Don't give up on yourself. These licensing situations, they take time, they take effort, they take money. Easy to get frustrated and walk away from it. Don't do that. Get yourself legal, and be nice to be able to drive without looking over your shoulder and looking in the rearview mirror, hoping that nobody's observing. I'm going to wish you the best of luck. You take care of yourself. I want you to get a copy of today's paperwork at the window outside the courtroom to your left. And review it carefully, and call Mr. Haverko if you have any questions, okay? Good luck to you. back to square one.
Next matter, Your Honor, excuse me. That's Christopher Polito. He's number 12 on the 10 o'clock calendar. Comes on before the court for a pretrial hearing on the charge of criminal trespass first degree. Parties have reached an agreement. He is going to enter a straight plea guilty to the amended charge of criminal trespass in the second degree. Recommendation is 90 days in jail, all suspended for 12 months on the condition that he pay a $250 court fee and just remain law abiding.
Good morning, sir. Do you disagree with anything at all that Mr. Haverko just said? Full name is Christopher Polito. Mr. Polito, I'm looking at an amended charge of criminal trespass second degree contained in a statement of defendant on plea of guilty. Have you gone over the plea process with your attorney? Now, the plea form tells me you're 32 years of age. Any issues at all, difficulty understanding the plea process? If I accept the plea, I could sentence you to up to 90 days in jail and about to $1,000 fine, regardless of what's recommended. You realize that. Also, you give up the rights contained in paragraph 5, no trial, no appeal, if I accept the plea. With that in mind, as to one count of criminal trespass and the second degree alleged to have occurred within the city of Yelm on get to the right page.
It's on
December 10th, 2022. How do you plead guilty or not? You make that plea of your own free will. Anybody make any threats or promises to you to make the plea? We'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. City, have anything to add? Mr. Haverko?
nothing to add, Your Honor.
Mr. Polito, you have a right to tell me anything you want me to hear or think I should know. You don't have to say anything. So,
Thank you very much.
the recommendation is a good one. I'm going to follow it. 90 days, all suspended on the condition you have law-abiding behavior. Don't go to places you have been trespassed from. And the probation fee, $250. That can be taken care of over time, and that's the least important thing to me. If there's a issue problem making the payments, let us know, okay?
Sure.
Good luck to you.
Thank you.
And again, get a copy of today's paperwork at the window, review it carefully, and give Mr. Haverko a call if you have any questions. Good luck to you.
Thank you.
You're welcome. I need to speak with Mr. Lucas. I think the other gentleman is waiting for a private counsel.
Oh, okay.
Yeah.
Good morning. We'll address the matter of Eric Furman Avita at this time. Mr. Avita is in the courtroom. Eric Furman Avita? Good
Yes, Your
morning. I'm going to defer to your attorney who's online. He's here by way of Zoom.
Yes, Your Honor.
Judge Rao, good morning.
Good morning, Your Honor, and I'm here for Mr. Avitia, who's in person in the courtroom today.
Good. I'll defer to you. I'm
Okay.
looking in the old court, say a petition for deferred prosecution. That's it.
Yes, Your Honor. We are asking the court to accept a petition for deferred prosecution here. I want to let the court know that Mr. Avitia has been in treatment since this case has started. He's doing incredibly well. We have reviewed the documents in detail. He has also read the petition himself. We've reviewed everything that comes with a deferred. He understands the treatment, exactly what he needs to do. He has been in total compliance since he started, and he's financially able to complete that treatment. Additionally, Your Honor, he understands that he's giving up his trial rights by entering this deferred prosecution, if Your Honor does accept it. He wants to do that, and this is the path that he wants to take, and we think it's best for him. Thank you, Your Honor.
Thank you, sir. Mr. Avita, it takes a moment to review the paperwork that I have actually on a computer here in front of me. A lot of it is a boilerplate, but it's going to still, I want to review it a little bit.
Yes, Your Honor.
And Your Honor, I do want to confirm my office did submit an assessment. We submitted a commitment to treat, an updated status report, and I believe that was it.
Mr. Avita, there was a time back when a deferred prosecution was a kind of a way out of something. Not so anymore. I have nothing but respect for somebody that says, hey, look, I've identified a problem in my life, and with the help of a treatment program, we're going to take care of that problem and go ahead and have a better life. I think it's sometimes it's under today's rules and regulations and laws, as your attorney, and can probably agree with me. This is the harder road to take. Sometimes it would be easier to simply plead out to a DUI and in many cases go on to get another one at some point down the road. I have nothing but respect for somebody that addresses a situation head on and is going to take it on. I'm going to approve of the order of admitting you into the program. It sounds like you've gone over with your attorney, what you're expected to do and the obligations that are imposed on you by that. At this point, all I can do is wish you the best of luck and all the success in the world with regard to the program that you're going to be in here. Do you have any questions, or is there anything you'd like to tell me or let me know?
No, Your Honor. Thank you very much, and thank you for your time.
Thank you, Mr. Avita. I'm going to be signing the necessary order here. You'll be sent a copy of that, as your attorney will, and what I want you to do is review it carefully once again. And if you have any questions at all, give your attorney a call. I'm always here to address any situations that come up if any problem should arise. I want to wish you the best of luck. You take care of yourself. You can get a copy of today's paperwork by going to the window outside the courtroom, but we're going to have to mail your attorney a copy. Good luck to you. Any questions?
No, Your Honor.
Hearing's over. You may be excused. Take care.
Thank you, Your Honor. And,
Take care. Have a good day.
well, Your Honor, I want to inquire, is Mr. Ragers in the courtroom?
Apparently, I'm told that he's on Zoom.
Oh, he's on Zoom. Okay. Your Honor, let me inquire with the court. Mr. Nerlich, his attorney of record, who I work with at my firm, he's in trial right now. So I was going to cover this hearing for him. Are we able to resolve a matter with both parties over Zoom?
We can certainly bring that up, yes.
Okay.
Mr. Rakers, are you able to hear me?
Yes, I am.
Mr. Rakers is present. Mr. DeBeo is here. He's standing in for your attorney today.
Yeah, I spoke to my attorney this morning and he made me aware of that.
Okay. I'll turn to Mr. DeBeo for the status of the matter.
Yes, Your Honor. Resolution has been reached in this matter. Mr. Nerlich has indicated that he has uploaded some plea paperwork to O Court. And if possible, Your Honor, we'd ask the court to enter the change of plea today.
Good afternoon. Is your full name Nicholas Aaron Rakers?
Yes, Your Honor.
Mr. Rakers, I'm looking at a statement of defendant on plea of guilty to one count of reckless driving in the O Court system. Plea form tells me you're 44 years of age. You have a GED. Have you gone over the plea form with your attorney?
Yes, I have, Your Honor.
And if you had any questions about what it meant to enter a plea of guilty to one count of reckless driving, was your question answered?
I didn't have any questions. I seem to understand the written document pretty well.
I want to make sure you understand that if I accept the plea, you give up the rights contained in paragraph 5, there's no trial, no appeal, simply a sentencing, which this being a gross misdemeanor could be up to 364 days in jail and or a $5,000 fine, regardless of what's recommended. You realize that?
Yes.
Mr. Rakers, with that in mind, as to one count of reckless driving alleged to have occurred within the city of Yelm on April 17th, 2022, how do you plead guilty or not guilty?
Is that for the reckless?
Yes.
Yeah, I plead guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. With regard to the recommended sentence, turn to the city. Yeah. The city recommends 364 days in jail, all suspended for a period of 2 years on some conditions. I'm going to refer to your attorney for those conditions.
And thank you, Your Honor. This is an agreed recommendation. I would ask the court to follow it. Of course, I'm not. I haven't known Mr. Rakers for very long, but I spoke with Mr. Nerlich about this matter. Mr. Rakers has no prior history, and Your Honor, he's an incredibly hard worker. As he's sitting in front of you right now, he's been up for about 17 hours straight. So I'm sure he's looking forward to having this over soon. But he's also looking forward to having this matter over soon. He's been working through it a very long time, since 2022, April, I believe. Mr. Nerlich notes that he's done everything that he's asked him to do. And he's been very, very communicative and responsive. And Your Honor, I believe it's an appropriate recommendation, and I'd ask the court to follow it. Thank you.
Mr. Rakers, the recommended conditions are there's a restitution box checked. There is no amount entered. I take it that's a reserved issue. No criminal law violations. Do a drug and alcohol evaluation and file proof with the court within the next, say, 120 days, if you would. That will result in a recommendation, no doubt, to at least attend a victim impact panel and do attend drug and alcohol classes. Is there any recommendation as to fine? if I'm reading this correctly, it's a $500 recommendation. That's it. Mr. Ayers, the fine is in the amount of $500. We'll set you on a payment program for that. That is the least important thing to me here is that do you pay that fine? If you have trouble making the fine payments, let us know. The important thing is that you learn from this and not go on to make any further mistakes when it comes to drinking and driving. Do you have any questions?
I do not.
I'm going to wish you the best of luck and you need to get some rest here, okay?
Thank you, Your Honor.
You take care of yourself. We'll be sending you a copy of today's paperwork and your attorney, he'll get a copy as well. And given the way today's hearing went, if you have any questions after you review the paperwork, give your attorney a call, okay?
Thank you.
That concludes the hearing. You can sign off. Mr. DeRayo, thanks for standing in. You take care of yourself and have a good day.
You as well, Your Honor. I appreciate it. Thank you.
Back on record, Mr. Everco will once again defer to you for the order.
So this is Juan Carlos Lopez. For a matter comes on for the court for a DUI charge, he has no prior DUI.
Good afternoon, sir. Is your full name Juan Carlos Lopez Perez? I mispronounced your name, but I apologize for that. It was a. Do you disagree with anything at all, Mr. Haverco just said? He's worked out an agreement for you, a contract between you and the city here, under the terms of which, 2 years down the road, this charge can be amended to a much less serious charge of negligent driving in the first degree. It would go on your record as such. Now, in return for the agreement, you've given up the rights contained, you've given up all rights to go to trial. You cannot, if you violate the agreement and the city proves that, we'll have a hearing based on the police report. And you know what the result of that would be? Almost a certain conviction for DUI. And that would bear the possibility of significant jail time, as well as a lot of consequences as far as your driver's license is concerned. What you're agreeing to do is, most importantly, stay out of trouble. No further criminal law violations, especially when it comes to drinking and driving. Within 120 days, get a drug and alcohol evaluation and start complying with any treatment recommended. And the treatment recommended will at least consist of a victim impact panel and drug and alcohol information school. The costs are $990.50. We'll put you on a payment program of $45 a month on that. If you can't make the payments, if you have an issue making them, let us know. We'll say, okay. Now, you have a chance to get this very serious DUI amended to a simple misdemeanor, but it's up to you to take advantage of the agreement that you now have. Any questions at all? The good thing is you are here. You know, so many, all you have to do is read the newspaper. We kill thousands of people every year, drinking and driving, all, you know, mostly done by people that just want to live life and ordinarily wouldn't hurt anybody, but for the fact of the impairment due to substance. I'm going to wish you the best of luck. You can get a copy of today's agreement by going to the window outside the courtroom, read it over carefully, and if you have any questions, give your attorney the call. Any questions if you'd like to ask of me? Good luck to you. Take care of yourself. Back to the dashboard. Go ahead.
Your Honor, this is Titus Williams. He has two matters, 11 and 12 on the 11 o'clock calendar. One matter is a compliance diversion case that I was already appointed on, and that's with regard to an SOC violation. And then he has a new newer case that comes on for the pretrial hearing. And that was a case where Joshua Sneva had previously been appointed to represent Mr. Williams. So we had this odd situation where Mr. Sneva represented him on the new case pretrial, and I still represented Mr. Williams on the older case. So assuming he still wants a court-appointed counsel, it's a pretrial hearing, but I'd ask the court to inquire about whether or not he wants a court-appointed lawyer, and there'd have to be I'd need to be appointed and then get a copy of the report.
Mr. Williams, would you like a court-appointed lawyer for that to replace Mr. Sneva? I'll appoint Mr. Haverco to represent you on that matter as well.
What's your thought? Okay.
And a order resetting the matter to August 31st, 10 o'clock in the morning. Is that gonna work?
Sure.
Mr. Williams, give you a chance to get up to speed with your new attorney on the pretrial case. That's, we're gonna reset the matter to August 31st. I'll sign an order to that effect. I'll have you sign off on it as well. Mr. Haverco's contact information will be in that, will be in the order. And
It's working. There you go. Cool.
Mr. Williams, I want to thank you for appearing. You take care of yourself. Get a copy of today's order. Don't forget at the window outside and to the left, and stay in touch with Mr. Haverco, and we'll see you back here at the end of the month. Any questions at all? Good luck.
We'll talk about it. So the court's ready. Did the court want to do any no-shows or?
We certainly can.
Okay.
We certainly can. Let's. So you had a 9:45 warrant quash
They didn't show, right?
request that was not show. I guess we'll just simply strike.
Right, that's right.
At 10 o'clock.
On the 10 o'clock, there's Brighton Mead, MEDE. My notes reflect that I've never had contact. with
Oh,
the-
he showed up with a private counsel.
Oh, he did?
Who got the
Oh.
matter reset to September
Oh.
28th.
Okay, so I've been withdrawn. Okay,
We're only
okay,
missing
got it.
Albert Phillips.
Okay, and I called him very recently, like in the last week. And I did reach him on the phone and he said, let me call you back in 5 minutes. And I said, okay, we'll talk about your case. Never heard back.
Pretty long 5 minutes.
Yeah, I'm still waiting. So maybe it's 5 minutes, based on some other kind of, timekeeping, method.
Within the next 5 minutes, I think, Mr. We'll have a motor. So ordered, 2,500 cash or bond. Yeah,
And
only one warrant off the 10 o'clocks. That's,
on the 11 o'clock, I called the number that I had for Kinsey Lee DeFord. And I wound up speaking with the defendant's mother, who was a very cogent, thoughtful person. And she said, it's just been a real struggle with this person. She's done like everything she can to try to get him off the street, off drugs. And she sounded like a very smart person. And at the same time, kind of resigned to at least this point in time that she just can't seem to really get him any help. So her comments were, she said he probably won't show because she has no idea where she is, how to get a hold of him. He's doing drugs. So that's.
well, that was his new charge, that he's supposed to be here at 1 o'clock, loitering, drug-related activity, and he was obviously far under the influence when he was arrested.
Yeah.
I did, he was booked into custody. I released him on his promise to appear today, and it looks like mom was a little prescient. I'm assuming that he will not show up at 1 o'clock, but we did not be 1 o'clock. We don't know that yet.
Yeah.
On the three, on docket numbers 2, 3, and 4, does the city wish a warrant provisionally entered on them? We may be adding to that on the 1
Yeah.
o'clock.
And
1,000 cash or bond on docket 2, 3, and 4.
and then moving on to the 11 o'clock, Chad
Present.
Krzan. I actually got a phone call from, I think, a girlfriend like a day or two ago, and she was saying that Chad, this is just as of either yesterday or the day before. She said that Chad had presented himself for some kind of evaluation to do some inpatient treatment. She didn't know whether it would be for 30 days. She said it could be anywhere from 30 days to 45 days. And so I said, well, it would be helpful if you could get the treatment place to send me something, email me some kind of proof. Nevertheless, she did call, and not having any reason to not believe her. I guess my position would be just to note the non-appearance for speedy trial purposes and ask to reset with notice. I would err on the side of 60 days because if it could take up to 45 days for the treatment to be released, I would suggest setting a notice for approximately 60 days from today's date.
City had any problem with resetting the matter? Note the non-appearance for speedy trial purposes, and given the nature of Grim Trust too, and they're both simple misdemeanors, and let us engage in the fond hope that he has entered a treatment program.
I got it on the next matter, Alexis Danielle Magnasco. I was handed a note by the court clerk. I guess the call came in at 11 a.m. It said that she called and she had car trouble, but is on her way. So I would ask the court to just maybe postpone action on that and see if she shows.
That was Alexis. I missed it.
And I have talked to her. So I spoke with her in the last few days, and we have kind of an agreement worked out. So I hope she shows up.
Let's reset Chad Kazan to let's go September 28th, 9/28. And Alexis Magnasco will
Just
wait her appearance.
just wait. And then,
And Joe Murphy.
yeah, haven't had
Joe
any
Murphy.
haven't had any contact with Joe Murphy. I called and left a message. I haven't received any return call. I have no information as to his non-appearance.
1,000 cash or bond
Yeah.
on Murray. 1,000 cash or bond, so ordered. And we'll see if Ms. Magnasco.
Yeah,
We'll see if she
so
shows
let's
up.
see, she may, I guess. I'm hoping she shows, and maybe if she's late and gets here in the lunch hour, maybe we could take it up at 1 o'clock.
Sure. Oh, yeah. Second record, I'm going to call the matter of Yelm versus Alexis Danielle Menyasio. Good afternoon, ma'am. If I mispronounce your name, I apologize. I'll defer to your attorney for the
Thanks, Judge.
status of the matter.
Thank you, Judge. So this is Ms. Alexis Danielle Magnasco, comes before the court for a pretrial hearing of criminal trespass in the first degree. I have discussed her case with her. Parties have reached an agreement. She's going to enter a straight plea to the reduced charge of criminal trespass in the second degree. 90 days of jail, all suspended. To never be imposed, so long as during the next 12 months she commits no new criminal law violations and pays a $250 court fee at $25.
Ma'am, do you disagree with anything at all Mr. Haverko just said? I'm looking at a statement of defendant on plea of guilty to one count of criminal trespass, second degree, amended down from criminal trespass, first degree. Plea form tells me you're 30 years of age. Do you have any issues, any problems reading, understanding the plea form? Have you gone over the form with Mr. Haverko? And if you had any questions about what it meant, were your questions answered? Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal. There'll be a sentencing which could be up to 90 days in jail and up to $1,000 fine, regardless of what's recommended. This is a simple misdemeanor. Any questions about anything I've just said? As to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on March 28, 2020, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Mr. Redfield, city have anything to add? Mr. Haverko, anything to add?
Nothing to add, Judge, just follow the recommendation.
Denisco, you have a right of elocution, which means you can tell me anything you think I should know or you want me to know before sentencing. You don't have to say anything, but if you do have anything you want me to know, now's the time. Recommendation's a fair one. I will follow it. 90 days, all suspended on the condition you have law-abiding behavior and pay a $250 probation fee. We'll say on a payment program with regard to the probation, the costs. If you have trouble making the payments, let us know. We can deal with that. The most important thing is you've learned from this. Law-abiding behavior that includes not going where you've been, from which you've been trespassed. Any questions at all? I'm going to wish you the best of luck. The paperwork, it's all on a computer now, will be reduced to a paper copy. And I want you to get a copy of that at the window outside the courtroom to your left. I want you to review it carefully. And if you have any questions at all about about the contents of it, give Mr. Haverko a call, okay? I'm going to wish you the best of luck. You take care of yourself. Have a good day.
Take care. Okay.
And with that, we'll go
It's a
off.
wrap.
Hey, Dan? Now on record, I'm going to call the 1 o'clock calendar. Before I call you up one at the time, I need to advise you of the fact that you have a right to have a lawyer represent you at all stages of any criminal proceeding, including today's hearing, your arraignment. Mr. Haverco, our public defender, is in the back of the courtroom. He will, regardless, enter a plea on your behalf today, and he will represent you throughout the course of your case if you're indigent and request his services. At an arraignment hearing, the only plea that's entered is not guilty to the charge that you're cited for. Plea of not guilty is not any great statement about the case. It's simply a preservation of your rights, pending what they call a pretrial, which is what your case will be set for. That's a chance for you to go over the that citation, discuss the case with your attorney, and he in turn with the city attorney, Mr. Ratfield, who's seated here to my right. Resolve the case if you can by agreement. That's not always possible. In the event that it is not possible, you have a right to a public and speedy jury trial in the county where the offense is alleged to have been committed. If you have any question about your rights, about what you're charged with, please ask either myself or Mr. Haverco any question you might have. Before the court is Devin Ray Adair. Mr. Adair, good afternoon. You were cited for driving a license suspended or revoked in the 3rd degree. That charge is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. The city may have a motion in your case.
City moves to amend the charge to no violence.
No all, and the 2nd degree is a civil infraction, meaning no valid operator's license on your person, but with ID. As you walked in, you were charged with a criminal offense. The city has moved to amend it to an infraction. You don't plead guilty or not guilty to an infraction. You admit it or deny it. If you admit the infraction, I will assess a $150 fine. That closes the case. If you deny it, we can set it for a contested hearing. Any question about anything I've just said? What would you like to do? I'll assess a $150 fine. Do you know what you need to do to get your license reinstated?
Yes, I just need to pay my
Money.
big amount.
Oh, great. Yeah, I'd make that a priority in life. We'll set your payments at $25 a month. If you have any problem making the payments, make sure you get a hold of us so we can always deal with that. We don't want the matter to go back to the Department of Licensing at FTA. I'm signing an order to that effect right now. That is something I do on a computer screen electronically. Mr. Adair, what I want you to do is go to the window outside the courtroom and to your left, get a copy of today's order. Good luck to you and good luck getting your license reinstated. You have a good day. Oh, you do. We have private attorneys here. I prefer to call those matters first. I see, I did note that Mr. Valley was on. Is Melissa Ulrich in the courtroom? Ms. Ulrich, if you'd step forward, we're going to take your matter now. Mr. Valley is here by way of, and he will be representing you in this matter. Is your full name Melissa Jean Ulrich? There's a way to mispronounce a name. I'm gonna do that. Ms. Ulrich, good afternoon. Excuse me. The citation alleges that on or about July 5th, 2023, you committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. I will turn to your attorney for the entry of a plea on your behalf. Mr. Valley?
Thank you, Your Honor. I advise the court. Yes, can the court hear me?
I certainly can. Go ahead. I can hear you perfectly. The
Great.
question, can you
My
hear me?
client and I, my client, yes, I
not-
can. Ms. Ulrich understands the nature of the charge against her. We waive any. Can the court pick this up?
It's, you're coming and going. That's, I'll hear. a
Okay.
word, and then you cut out.
We waive any reading and ask the court to accept a not guilty plea, Your Honor.
Stipulation to probable cause.
Yes, Your Honor.
Ms. Ulrich, a plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial at this time. Mr. Valley, August 17th or 31st.
I think because of my client's circumstances, Your Honor, I would ask in this instance for the 31st. I would usually go sooner than later. In this instance, I would ask for the later, please.
City has no objection.
Unless Ms. Ulrich
We'll set that for
pipes
the end of the month.
up and says differently.
August 31st. Is that going to work with you, Ms. Ulrich?
Yes.
Okay. Conditions release, of course, are law abiding behavior. You don't need to write this down. You're going to get a copy of the order today. Conditions of release are law abiding behavior. Don't drive unless you're licensed and insured. Don't drink and drive at all. Any officer asks you to take a breathalyzer, you're to do so. Mr. Valley, any objection to any of the conditions?
No, Your Honor. Thank you.
Ms. Ulrich, how about you? Any questions? I'll sign an order on today's hearing. We'll send Mr. Valley a copy of today's order, and you can get a copy of it by going to the window outside the courtroom to your left. Review that carefully, and if you have any questions, give your attorney a call, okay? Thank you for appearing. You take care. Have a good day.
We thank the court, Your Honor.
Thank you, Mr. Valley. You take care.
Likewise.
Anybody else here with a private lawyer? Yes, sir.
Me too.
We'll take your matter next. That is Davis. Good afternoon, Mr. Girl. You just went off mute. Can you hear me okay?
I can, Your Honor. Good afternoon.
And I understand you're appearing on behalf of,
Mr. Davis?
and I believe Mr. Davis is in the courtroom. He's approaching the council table as we speak. Good afternoon, sir. Is your full name Alexander Robert Davis? Mr. Davis, the citation I have alleges that on or about July 26, 2023, committed the offense of driving under the influence of intoxicants. That's what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to turn to your attorney for the entry of a plea on your behalf at this time.
Your Honor, good afternoon. For the record, Dan Carroll appearing on behalf of the attorney of record, Seth Toninga. For Mr. Davis, Your Honor, I know that counsel and Mr. Davis have discussed this matter. I believe that they've gone over the rights and arraignment. We would waive any further formal arraignment at this time. We'd ask the court to enter a plea of not guilty.
Stipulation to probable cause for purposes of this hearing only.
For those purposes only, yes, Your Honor.
Plea of not guilty has been entered on your behalf. That preserves your rights pending a pretrial. The conditions of release would be law-abiding behavior. Don't drive unless licensed and insured. Don't drink and drive at all. Any officer has occasion to ask you to take a breathalyzer, you're to do so. Mr. Girl, any objection to any of the conditions?
Yeah.
Any questions at all, Mr. Davis? Now, we're going to send your attorney a copy of today's order, but I want you to go to the window outside the courtroom and to the left. Get a copy of it, look it over carefully, and if you have any questions, give your attorney a call, okay? Concludes the hearing, you're free to leave.
Thank you, Your Honor. Thank you, Counsel.
Thank you and take care. Going to call the matter of Yelm versus Janet Florence Prince. Ms. Prince, we'll address your matter now if you're ready to be heard. Ms. Prince, good afternoon. You're now present. Would you unmute yourself? Unmute yourself and then tell me when you have.
Hello?
Good afternoon. Are you able to hear me?
Yes. Can you hear me?
I certainly can. Are you Janet Florence Prince?
Yes, I'm Janet Florence.
Ms. Prince, the citation I'm looking at alleges that on or about August 1, 2016, you committed the offense of theft in the third degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco, the public defender, who is here to represent you in this matter and enter a plea on your behalf at this time. Mr. Haverco?
Stipulate probable cause as the court to enter not guilty plea.
Ms. Prince, a plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial conference. That will be on August 31st at 11 o'clock in the morning. Does that fit with your schedule?
Yes, would I be able to still join Zoom on that matter?
Yes, the Zoom information, I'm looking at it on the today's order. You'll be getting a copy of that by mail here shortly. And yes, you can sign in and appear by way of Zoom on that date, okay?
Okay, thank
I'm
you.
gonna need some kind of contact information.
Now,
Okay,
Mr. Haverco is going to need some contact information. I don't need to get your telephone number on the record here, but if you could
Okay.
message that to message that in, that can be passed on by Madam Clerk to your attorney, okay?
okay,
If, just as an FYI, and so my email address, it's yelmpublicdefense@gmail.com, Yelm Public Defense, all one word @gmail.com. If you could email me your name and contact information so I can call you.
okay, thank you.
Ms. Prince, yes, that's it. And for your reference, the mailing address, telephone number, and email address are going to be on the order you're going to get. So yes,
Okay.
very important that you make contact with Mr. Haverco, okay?
Okay,
Ms. Prince, that concludes today's hearing. You take care, and we'll see you here at the end of August.
okay, thank you.
Have a good day.
You too.
Danny Alford in the courtroom? Danny Alford. Does not answer. How about Samuel Barstead? Now, a number of people, names that I'm going to call, will not answer. After the calendar is over, I will go back through the cases. If there is probable cause to issue the citation to the non-appearing individual, I'll issue a warrant for their arrest. So you've saved yourself at least a warrant for your arrest by just showing up today, and I want to thank you for that. Samuel Barstead did not answer. How about James Bittner? Mr. Bittner, if you would step forward and have a seat. Good afternoon, full name James Anthony Bittner.
Yes, sir.
Citation alleges that on or about July 28, 2023, you committed the offenses of violating a protection order and also obstructing a law enforcement officer. Each of those charges are what they call a gross misdemeanor. The maximum penalty would be 364 days in custody and or a $5,000 fine. I'm going to appoint Mr. Abercrombie to represent you, and he'll enter a plea on your behalf at this time.
So stipulate probable cause, support to enter not guilty, please.
Mr. Bender, pleas of not guilty have been entered with regard to both charges. We're going to set the matter for a pretrial. Conditions of release, of course, are law-abiding behavior, and that especially applies to no contact orders, orders of protection. It's very important that those be abided by. Your pretrial will be August 31st at 11 o'clock in the morning. I'm signing electronically, signing an order to that effect at this time.
Wait. Can't sign it. Go. We're done?
Are you done?
Yeah.
Mr. Bittner, sorry, I thought you were talking to, that concludes the matter. What I want you to do is get a copy of today's order. That's at the window outside the courtroom and to your left. So, any questions at all? Good luck to you. Take care. How about Kia Brantley? Kia Brantley, answer. Ms. Brantley, if you'd have a seat at the council table, we'll address your matter at this time. Is your full name Kia Jock Brantley? If I mispronounce your name, I apologize. Citation alleges that on or about July 6, 2023, you committed the offense of assault in the 4th degree domestic violence. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Abercrombie to enter a plea on your behalf at this time, and he will do so.
Stipulate probable cause, Your Honor, as support to enter not guilty, please.
The usual stipulations as to PC. Probable cause.
Stipulate probable cause, Your Honor.
Ms. Bradley, plea of not guilty has been entered on your behalf. That preserves your rights. We're going to set the matter for a pretrial. That'll be on August 31st at 10 o'clock. Conditions of release are law-abiding behavior, stay out of trouble. And I see somebody in the courtroom does wish to be heard regarding the matter.
Yep, just. Yes,
If he's willing to talk to you, take a few moments, that's usually, that's contact information is exchanged at this time, but okay, go ahead. This is Kia Brantley, docket number 5, page 11. And for the record, your name is? Mr. Graves, go ahead. Ms. Brantley, that concludes the hearing. Sign an order to that effect, setting the pretrial. I want you to get a copy of that at the window outside the courtroom to your left. Any questions at all? Good luck to you. See you at the end of the month. Take care. Ren Burnham does not appear to be here. Alexander Davis has been, we've dealt with that. Kinsey DeFord. Kinsey DeFord in the courtroom. Does not answer. How about Eric Flores? Calvin Goodman. How about Lance Houston? Mr. Houston, if you would come on up and have a seat next to Mr. Abercrombie. Good afternoon to you. Is your full name Lance Scott Houston? Mr. Houston, the citation alleges that on or about July 18th, 2023, you committed the offense of obstructing a law enforcement officer. That's what they call a gross misdemeanor. Maximum penalty upon conviction would be 364 days in jail and or a $5,000 fine. Mr. Houston, I'll appoint Mr. Abercrombie to enter a plea on your behalf at this time.
Thank you, Judge. Stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Houston, a plea of not guilty has been entered on your behalf. Again, that preserves your rights. We're going to set the matter for a pretrial. That'll be on August 31st at 11 o'clock in the morning. Conditions of release are law-abiding behavior, stay out of trouble, appear for court as directed, and stay in touch with your attorney. Any questions at all about the charge or your rights?
Yeah, I need, if you have one. 350.
Mr. Houston, again, get a copy of today's order at the window outside the courtroom to your left, and we'll see you in here at the end of August. Take care. Greg Jensen. Greg Jensen does not answer. How about Kevin Jones? Good afternoon. Are you Kevin John Jones Jr.? Mr. Jones, the citation alleges that on or about July 28, 2023, you committed the offense of criminal trespass, 2nd degree. Now that charge is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I'll appoint Mr. Abercrombie to represent you, Mr. Jones, and he'll enter a plea on your behalf.
Thank you, Your Honor. Would stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Jones, a plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial. Conditions of release are law-abiding behavior. Stay out of trouble. Stay in touch with Mr. Abercrombie and of course appear back here on August 31st. Okay. Any questions?
Okay. Cool. Courtney.
Jones, thank you. You take care. You have a good day. Again, get a copy of the order at the window outside the courtroom and to your left. Next would be Regulus Knight Lightcaster. Good afternoon, sir. Have a seat. Is that your full name? Mr. Lightcaster, the citation I have alleged in honor about July 16th, 2023. He committed the offense of driving the license suspended or revoked second degree and violating the ignition interlock requirement imposed on you by the Department of Licensing. Each of those charges is what they call a gross misdemeanor. The maximum penalty for each would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Appico to represent you in this matter. He'll enter a plea on your behalf at this time.
Thank you, Your Honor. Stipulate to probable cause and ask the court to enter not guilty, please.
Any question about what just happened, Mr. Lancaster? We're going to set the pretrial for August 31st, 10 o'clock in the morning. Conditions of release are just standard. Law-abiding behavior, stay out of trouble. Stay in touch with Mr. Haverco and appear at your next court date.
Ready to go? Yeah, just go to the clerk to get your paperwork, take a left.
Mr. Lancaster, there was a civil infraction along with
Oh.
that. We'll just calendar that along with the criminal cases. Hey, take care and thank you. How about Tesla Moore? Does not answer. Tana Morgan. Bradley Nabokowski. Mr. Nabokowski, good afternoon. Full and correct name, Bradley Weston. You're here for two matters. One is a case that was set for a pretrial. It's still pending. The date of violation on that was January 14th of 2020. You're here for arraignment on a new charge. Those charges are theft in the third degree, criminal trespass, first degree, alleged to have occurred within the city of Yelm on September 2nd of 2020. I will appoint Mr. Haverco to represent you in this matter. They're both gross misdemeanors, 364 and 5,000 each. Mr. Haverco?
As to the arraignment charge, stipulate to probable cause, ask the court to enter not guilty, please.
Mr. Nabokowski, we're going to set both citations for August 31st at 11 o'clock. Your attorney in their first case was Josh Neva. I'm appointing Mr. Haverco to represent you on both cases at this time. Any questions at all? I want to thank you for appearing, but be back here on August 31st.
I need from
Nabokowski, good luck. Again, don't forget to get a copy of today's order at the window. Robert Sasser in the courtroom. Robert Sasser. Good afternoon. Full name Robert Gray Sasser. The citation alleges that on or about July 24th, 2023, committed the offense of harassment. The charge is a misdemeanor, gross misdemeanor, the maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Mr. Haverco, I'm appointing him to represent you in this matter, and he'll enter a plea on your behalf at this time.
I think Your Honor would stipulate to probable cause, ask the court to enter a not guilty plea.
Mr. Sasser, a plea of not guilty has been entered on your behalf. That preserves your rights. We're going to set the matter for a pretrial. Conditions of release, of course, are law-abiding behavior, stay out of trouble, stay in touch with Mr. Haverco and appear for court as directed. Pretrial will be August 31st at 10 o'clock in the morning. Any questions at all?
Three, four, six. Sure. Sure, sure. Yeah. Yeah. we'll talk.
Mr. Sasser, again, get a copy of today's order at the window outside the courtroom and to your left. Good luck. Austin Schoonover. Good afternoon, sir. Is your name Austin James Schoonover? Mr. Schoonover, the citation I have alleges that on or about July 16th, 2023, you committed the offense of driving while under the influence of intoxicants, driving a license suspended or revoked in the 3rd degree. DWI is a gross misdemeanor. The maximum penalty would be 364 days in jail and or a $5,000 fine upon conviction. Driving a license suspended or revoked 3rd degree is a simple misdemeanor. Maximum penalty on that upon conviction to be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you at this time.
I think Your Honor stipulate to probable cause, ask the court to enter a not guilty plea.
Mr. Schoonover, a plea of not guilty has been entered on your behalf. That's when I spoke to you on the telephone when you were in jail at the Nisqually Tribal, then I ordered you to get the ignition interlock and then file proof within 5 days. We never heard another word for you. I issued a warrant for your arrest because of that.
Oh, I didn't know.
This is something we discussed over the telephone.
Yes, I know. So I didn't know that. Your Honor, I don't have a car, but I can take it. So I don't have to a vehicle. I didn't. I'm sorry. I should have.
Yeah, we need to hear from you. That was we'll quash the warrant and you've represented in open court that you don't have a vehicle and you don't have access to a vehicle. We're going to set the matter for you pre-trial. And Mr. Schoonover, that's standard conditions of release, law-abiding behavior, don't drive unless you're licensed and insured. That looks like that could well be an issue here. Don't refuse to take a breathalyzer if you're asked to do so. And also order that you not drive a motor vehicle unless it's one that's equipped with a ignition interlock. The law does require that I impose that condition based on your history. So. Yeah.
Could you hang around just for a little bit? I'd like to check with you before you go on your. Yeah, just wait. When you're done.
Pre-trial would be August 31st. And again, Mr. Schoonover, I want you to get a copy of the day's order at the window outside the courtroom to your left. Good luck. Sarah Shalhoub, Stacy Marie Scartvet. Jason Tipton. Full name Jason Eugene Tipton. Mr. Tipton, the citation alleges that on or about July 30th, 2023, you committed the offense of loitering in connection with a drug-related activity. That's a gross misdemeanor. The maximum penalty and conviction to be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Tipton, the plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial August 31 at 11 o'clock in the morning. Law-abiding behavior, no consumption of non-prescribed drugs, and appear back here for your next hearing. Okay? Any questions?
Just wait a second. Wait a second. Put your, do you have a phone number? Oh, it is?
I'm not sure.
Who can't sign? Go ahead. Mr. Tipton, you mentioned to me that the address on the order is not current. Did you want to, did you have a? Oh. So just update it.
Mr. Tipton, it is pretty important to keep a current address on file with us, so just in case. As long as we have the current one. But yeah, I'll go. As long as we can get mailed to you.
Yeah. Yeah, there you go.
Good luck. Alexander Valentine. Ivani Villegas. Good afternoon, ma'am. Is your name Ivani Rose Marie Villegas? Good afternoon. You were cited for failure to transfer title within 45 days. You're also cited for not having insurance. In your case, the city may well have a motion. Well, I'll explain that, Ms. Villegas. As you walked in here, failure to transfer title within 45 days, that charge is it's a criminal offense. Convicted of that, you could get sentenced up to 90 days in jail and up to a $1,000 fine. The city's amended the charge, changed it from a criminal offense to a civil infraction. The civil infraction is invalid tabs, no valid tabs on the vehicle. Now that's being an infraction, there's no jail time that's even possible. If you admit it, I'll impose a $150 fine. If you deny it, we can set it for a contested hearing. In any event, if you admit it, that ends the case. Now, you were also cited for no insurance. If you admit that, that's the expensive ticket. I would reduce that to 150 as well. Now, that's your choice to either admit it and have a fine imposed or deny it and have a contested hearing set. You can deny that you committed any infraction at all, but oh boy. It changes the money picture a little bit, yes. in good time. I'm gonna, it's 150 each for a total of 300. And we'll set your payments at that at $25 a month. And your first payment would be due September 3rd. Now, financial circumstances change. If you can't make the fine payments, what I want you to do is let us know. We can certainly deal with that. We can sort that out. Any question at all? I'm signing an order to that effect. That takes care of the matter today. Yeah, keep your insurance in effect. Get the title in your name, and then you won't have that to worry about anymore. Any question at all? Now, I'm signing an order reflecting what we've done here today. What I want you to do is get a copy of that at the window outside the courtroom to your left. Look it over carefully, and if you have any questions, give us a call. Ms. Villegas, you as well. Thank you for appearing, and thank you for your patience. Nasha Williams. Tina Yaksik. All right, you, Miss Williams? Miss Williams, sorry. Go ahead and have a seat.
Oh, yeah.
Full and correct name, Nasha, middle initial D, Williams. The citation I have alleges an honor about July 15th. You committed the offenses of hit and run attended. Now that charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days jail and or a $5,000 fine. You're also cited for no valid operator's license without ID. That's a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter, and he's going to enter a plea in your behalf at this time.
Stipulate probable cause on both cases and ask the court to enter not guilty, please.
Ms. Williams, a plea of not guilty preserves your rights pending a pretrial. Conditions of release, of course, are always law-abiding behavior. Don't drive unless licensed and insured. Stay in touch with your attorney, Mr. Haverco, and appear for court as direct. Okay. Your pretrial is going to be August 31st at 10 o'clock in the morning. Now I'm going to sign an order to that effect. Yeah. Williams, I've signed an order to that effect. What I want you to do is get a copy of that at the window outside the courtroom and to your left. Look at the order carefully, and we'll see you back here at the end of the month. Any questions? I'm not.
No,
with the
those
thumb
are,
in the back.
no, those are just, he was just telling you what the maximums are that can be imposed. So nothing's happening. Just entered.
Yeah, nothing.
Guilty plea then.
Yeah, that's part of the process is I'm
Right.
required to let you know that's what the maximum penalty is. There's no way you're going to get sentenced to anything like that. But hey, you take care of yourself, get a copy of today's order, and we'll see you back here at the end of the month. You take care of yourself. Tina Yasik. Full name Tina Marie Yaksik. If I mispronounce your name, let me apologize for that, okay? The citation that I have alleges in honor about July 9th, 2023, you committed the offense of theft in the 3rd degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverko to enter a plea on your behalf, and he will represent you throughout the course of the case if you request his services and your indigent. Mr. Haverko?
Thank you, Your Honor. Would stipulate to probable cause and ask the court to enter a not guilty plea.
Plea of not guilty has been entered on your behalf. Again, Ms. Yaksik, that preserves your rights pending a pretrial. Any question at all? Your pretrial is going to be August 31st, 11 o'clock in the morning. In the meantime, conditions of release or law-abiding behavior, stay out of trouble. Stay in touch with Mr. Haverko and of course, appear back here on August 31st. Jackson, thank you for appearing. Don't forget a copy. That's, we did have it looks like a late arrival. Mr. Alfred, come on up and have we're glad to see you here. That's, hey, everything's okay. Your full name is Danny Lee Alfred, is it not? Mr. Alfred, the citation I have alleges that on or about July 22nd, 2023, you committed the offense of loitering regarding drug-related activity. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverko, our public defender, to enter a plea on your behalf with regard to the charge. And he will represent you if you're indigent and so request.
I think Your Honor, stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Alford, a plea of not guilty has been entered on your behalf. That preserves your rights pending the pretrial, which we're going to set for August 31st at 11 o'clock in the morning. In the meantime, law-abiding behavior, no consumption of non-prescribed drugs, appear for court as directed, and stay in touch with Mr. Haverko. Okay, any questions? That concludes the hearing. I'm going to be signing an order to that effect. Mr. Alfred, you can get a copy of that order at the window outside the courtroom and to your left. I want you to review it carefully, and if you have any questions, give Mr. Haverko a call, okay?
So before you go, just stop at the window. Yeah. Oh, yeah, yeah, I will. Yeah.
Mr. Alfred, it's good to see you here. You take care of yourself and make sure you get back here on August 31st, okay? Thank you, ma'am. For the record, is your name Tesla Kirsten Moore? Ms. Moore, the citations that I have here allege that on or about July 22nd, you committed the offenses of criminal trespass, second degree, and loitering drug-related activity. The second charge is a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. Criminal trespass, second degree, is a simple misdemeanor. The maximum penalty for that upon conviction to be 90 days in jail and or a $1,000 fine. I'll appoint Mr. Haverko to enter a plea on your behalf, and
Thank you, Your Honor. Stipulate to probable cause and ask the court to enter a not guilty plea.
We have not guilty's been on your behalf, Ms. Moore. Again, we'll set the matter for a pretrial.
It's working.
It'll be August 31st, 11 o'clock in the morning.
Is it the same number for him or the other night? Okay. Before you, yeah, so before you go, let's stop up and take the window and I'll print out, we'll print out. Don't have it. Okay, okay. Make a note of it.
Ms. Moore, you can get a copy of today's order at the window outside the courtroom to your left. And with that, I think we can say to do is go back on record with regard to Yelm versus Red Burnham. That would be page 11 of today's docket, item number 6. Mr. Burnham was originally released from the Nisqually jail back on July 12th. Next date he was to appear would be July 20th. I went over that with him telephonically. He would have been given a copy of the order before he left jail. He did not show, and we did not hear from him. A warrant was issued for his arrest. In the meanwhile, he was apprehended in public by a young police officer who field booked him, did not book him into jail on his warrant, given the fact that he had a couple of dogs with him and the officer didn't have any way of taking care of the dogs. Mr. Burnham was given and signed off on a court date of August 3rd at 1300 hours, 1 o'clock in the afternoon. It's now, it's after 2 o'clock in the afternoon. He did appear this morning and asked to have his case heard earlier, but before he could come into the courtroom, disappeared, left. Called his case at 1 o'clock. He has not reappeared. However, while we were on record, he did call the office and did speak to court administrator Sonia, and with no real reason why he didn't come back to court, insisted that he had felt sick in the morning, and given the fact that he is this is the second time he has not appeared, that's I'm inclined to and will issue a warrant for his arrest, $5,000 cash or bond. I do want to state for the record that Donnie Burnham is a relative by marriage. She works here in this office. I have made sure that she has nothing to do with this case, given her relationship by marriage, and will have nothing to do with the case, and the matter will not be discussed with her, nor will she have anything to do with the administration of that case, any way, shape, or form. With that, we're going to go off record. Good afternoon, back on record. Let's address the 2:30 infraction calendar. Have one case set for a contested hearing. Tyron Edwards. Mr. Everson, good afternoon.
Good afternoon, Your Honor. How are you?
So far, so good. The sun is shining. I'm not in Arizona. I'm not in Texas. I'm in Washington. The north.
It's not, yeah, it's not too hot.
It is. But I'll call your matter at this time. I presume there's probably some preliminary, a preliminary motion or so to.
Yes, sorry, Your Honor. Yes, Your Honor. I would make a preliminary motion to suppress the SMD reading. Although the officer does say in his narrative that he did test the unit before the stop, there's also a requirement that he test the unit for accuracy after the stop. There's no mention of that. It is a requirement with their training and also, I believe, under case law, City of Seattle versus Peterson. Absent accuracy of the unit after the stop, I don't believe there's a sufficient foundation. I move to suppress and dismiss.
The motion is granted. I'll sign an order.
Thank you, Your Honor.
Infraction. I'll send you a copy of the dismissal order. Clients always like to see that.
Yes, sure. Thank you, Your Honor. You have a great week.
Hey, I'm signing the order as we speak electronically. We'll be sending you a copy today. You take care. Have a good day.
You too. Bye.
Take care. And that, as they say, is that. Oh, boy. We're on record, may as well address the no-shows on the 1 o'clock calendar. A few more than I expected. The first one I have is Samuel Barstad. That would be page 11 and docket number 3. I do find probable cause for the issuance to him of a criminal trespass site. Warrant will issue 1,000 cash or bond. Next, I have Eric Flores. Following page. Well, first, before that, Kinsey Ford, we addressed his matters that were on the morning calendar. Warrants were issued in connection with them. I did previously find a probable cause for the issuance of a loitering drug-related activity citation to him. Warrant will issue 1,000 cash or bond. And Eric Flores, that's one of those that says draft on the, there is a lot of draft material in the file, but there's no narrative as to the offense itself. I went through it several times. The only narrative, there's a lot of pages here, but the only narrative is the Ryan's statement. There's no names mentioned in there. So I can't find probable cause for that case. I presume the officer did generate a narrative, but I don't have anything upon which I can determine probable cause at this time. So let's wait till we get a non-draft copy, I guess. But Calvin Goodman, do find probable cause for Crim Trust 2, issued July 14th, 1,000 cash or bond. Next would be Greg Jansen. That's a DOS third. Amend that charge to no vol 2 and FTA it. After that, Tana Morgan is the next one. Probable cause was previously determined with regard to a criminal trespass on her. The warrant will go out again, 1,000 cash or bond. Next would be Sarah Shalhoub. That's a recurring issue as well. Find probable cause for criminal trespass, 2nd degree, 1,000 cash or bond. The next one is Stacy Skartvekt. In any event, that's docket number 24, page 14. The individual has, at the age of 60, has one of the lengthiest criminal records, I would say, 99 cases. In any event, I do find probable cause for the issuance of a theft third cite to her, 2,500 cash bond. And next would be, and last would be Mr. Alexander Valentine. I find very strong probable cause for a theft charge for him. This it was strong enough to where it approaches organized retail theft of some kind. 2,500 cash or bond will issue for him. And that concludes the 1 o'clock calendar. We'll go off record.